in the note is that it enables trustees, executors and administrators in their capacity as such to sue or be sued without their beneficiaries being joined. And then it says that 19.7A1 lays down a general rule that trustees are the proper claimants in proceedings against third parties based on causes of action arising in respect of the trust in question. Beneficiaries who wish proceedings to be taken on behalf of the trust against third parties can require the trustees to bring those proceedings on terms of giving the trustees an indemnity.
Yes, we can see what's said in this. You just want us to look at A1 and A2?
Yes, please. The note to, so yes. Just the note in 1, the effect of the rule. Now, what the respondents say in their skeleton argument is they say that this simply says in the rule that a claim may be brought rather than shall be brought. So they say it's a power rather than an obligation. But the point as reflected in the notes is the fact that a claim may be brought in that way, i.e. without adding beneficiaries, means that no objection can be taken by the defendant or by any of the beneficiaries. So it does actually lay down a general rule rather than a discretionary principle, because it precludes the possibility of a claim by the beneficiaries, since if the beneficiaries could pursue their own claim, the defendant would be entitled to insist on their being joined, as otherwise the defendant would have no assurance that the trustee alone could give a good receipt upon discharge. Yet that's precisely what paragraph 2 of the rule provides. Any judgment is binding on the beneficiaries. So,
I see the rule is interesting, but a rule of court like this couldn't affect substantive cause of action or affect the law's analysis of who suffers the loss.
No, of course not, my lord. So we accept that. The reason I'm taking you to the rule is because we say that it does reflect the long-standing principle of English law, that where there is, and that's why I took you to Webster, that where there is a wrong which gives rise, causes damage to the trust property, then the correct claimant is the trustee, and the beneficiary doesn't have no separate cause of action is conferred on the beneficiary. Now, I want to take you to a judgment of the Court of Appeal of Victoria, so an Australian judgment, in the case of Young and Murphy, because that judgment grapples directly with the point being made by the banks in this case. They draw a distinction in relation to trusts, as well as in relation to companies. They say that there's a distinction between present beneficiaries and former beneficiaries. So they seek to draw the same distinction. And that distinction is grappled with in this authority. So it's in Authorities Bundle 6. At tab 62, page 1845. For those working from hard copies, unfortunately the page numbers are obscured at the bottom of the page, at least mine are. Mr. Hoskins are too, so the chances are the courts will be. I'll try and guide you through it by reference to the internal page numbers. But for Lord Justice Jackson, we pick it up at 1845. So 1846 is the head note. And you can see that, perhaps you could just read the head note, because that gives you the context in which, well, the facts in the head note at least.
Yes.
Thank you. And if you could turn to page 1862, which is internal page 295 at the top right-hand corner for those working from the hard copy. And so this is under the heading Claims Against the Former Trustee. And if you could look, please, at the bottom of the page, so line 43, for present purposes, that's sufficient to describe the way in which the claims against BPTC are pleaded. The appellants relied upon the fact that the pleading asserted only that the assets of the trust were lost or diminished and remain lost or diminished, and there was no allegation of loss suffered by any particular unit holders or any particular class of unit holders. Counsel referred us to the fact that since the commencement of the proceedings, there had been significant changes in the structure of the trust. By these changes, all of those who were unit holders immediately before the changes became instead unit holders in a holding trust. The holding trust was so constructed that for and on its behalf, 2 individuals became the only unit trust holders. What's being said here is that that there were changes in the identity of the beneficiaries, and that was what was being relied on. So when they came to argue later that former beneficiaries had to have a right to sue. And then if you go to page 296, you see at the top of the page, thus upon redemption, those former unit holders took a sum fixed otherwise than by reference to any rights against the old trustee to have it made the new trustee, to have it make good the trust assets, and similarly was explained the 2 individuals who became unit holders for and on behalf of the holding trust became unit holders at a price which again had reference only to net tangible assets and not to the value of any right of action for breaches of trust. So it's really an analogous argument.
I'm trying to just keep up with where you're reading from. I'm afraid the sidebarring a lot of these authorities has been so lavish as to really remove it.
I know, I'm so sorry.
Having any use at all. What internal page are we on?
We're on internal page 296, and I'm at the top of the page. It's about 4 lines down, so thus upon redemption. Yes. And, my lord, really the point that's being made is that there were beneficiaries, so unit holders, who redeemed their investment at a lower sum, so a sum that didn't take account of the fact that there was the new trustee had a good claim. So really it's the analogous argument, it's the same argument that's being made by the banks in this case. And then if we can stay please on the first page and then go 2/3 of the way down, the argument was that the new trustee was not entitled to make the claim. So you see that if you look, so under the heading, the second paragraph under the heading, a few lines down, it was submitted that while the unit holders, or at least the unit holders at the time...
I don't know what page we're on.
The same page, my lord, 296.
Yes.
So I'm towards the bottom of the page, about 3/4 of the way down. And there's a heading halfway down.
Yes.
I'm not looking at the first small paragraph, I'm looking at the second longer paragraph, and I'm a few lines down in that. So from it was submitted
yes.
that while the unit holders, or at least the unit holders at the time when the losses were suffered, might have been entitled to sue BPTC for these breaches of duty, the new trustees weren't entitled to make the claims for them, confronting the difficulty that the trustees commonly said to be the proper plaintiff to sue for wrongs to the trust property. The appellants contended that a new trustee was entitled to sue only in order to recover trust property, on the ground it was the legal owner of that trust property. In contrast, it was contended that the new trustee had no right to sue the former trustee for equitable compensation and damages for breach of duty owed to the unit holders, because that was not the recovery of trust property vested in the trustee for the time being. And so that's the argument, which is directly analogous to the argument that's being run by the banks in this case in relation to trusts. And if we can go to the next page, please, page 297. So at the top of the page, I'm not going to read it out, the first point being made is that the new trustee could sue the former trustee for compensation for wrongdoing affecting the trust property. And then if you go to line 17, please, happily it's not obscured on this page. Then it was said that the respondents, as current trustees of the trust, could sue only for those who are now unit holders and not for those who had been unit holders at the time when the loss and damage was suffered. Again, I think the submission should be rejected. The trustees are suing for loss or damage to the assets held on trust. and an order that the former trustee recoup that loss or damage does not answer the claims of particular beneficiaries. As I see it, the identity of the beneficiaries from time to time is irrelevant to such a claim. Old unit holders might have sold on terms that they kept such benefits as might flow from such causes of action, or alternatively might have sold at a price in anticipation of some recovery. That is a matter between them and their purchasers and cannot be known to the trustee. It does not affect the right or standing of the new trustees to sue in order to ensure that the trust property is properly maintained. Counsel was not able to refer us to any case in which an alteration in the identity of the beneficiaries had been considered relevant to a claim by the trustee against some third party to have the trust estate properly restored or compensated. So again, we respectfully endorse that reasoning and place weight on it. And then we see, then it was said, in this particular case, the trustees affected the result because of the provision for redemption, that units could be redeemed only at a price fixed by reference to net tangible assets. And skipping down to 45, what is said then is that the beneficiaries, upon redeeming their units, took in exchange for their units a redemption price which was wholly inadequate to reflect the trust property, if and when properly restored in consequence of BPTC's breaches of duty. That, it was said, was a loss for which they could still sue BPTC, and were it not so, success by the new trustees in their claims against BPTC for breaches of duty could result only in some windfall gain to the current unit holders. So you see, my lords, my lady, that it is precisely the same argument that was being run in that case as being run by the banks in the present case. And it's also the basis for the judgment on the trust issue below, which I'll come to the judgment below, that namely, what was said by the judge is that when a beneficiary redeems its investment at a price which is lower than it would have been absent the infringement, it suffers an independent loss for which it could sue. Otherwise, what's said is there would be a windfall to the current beneficiaries. And so this was the same argument that was being considered by the Court of Appeal, the Victoria Court of Appeal, and rejected. And it rejected the argument for several reasons, all of which are in our respectful submission correct. So if we look at those, please. So page 298, the top of the page.
Do you want us to read the whole of that first paragraph?
My lord, there's quite a lot to read, and if you don't want me to read it aloud,
I certainly don't want you to read it out verbatim. If you simply want to step through it, saying first, second, third, fourth, or whatever it is, please do.
My lord, I'll try and do that. It is quite dense, and we do place reliance on this. It does, in my respectful.
Why don't we read it first, and then you can comment on it. First paragraph on that page.
So, my lord, it's really the whole of the page. So I was going to take it in stages. But so maybe we'll start with the first part of the page.
Thank you. Yes.
So, my lords, my lady, we rely on that reasoning. So, in particular, on the fact that on redemption, the beneficiary loses the right to participate in the trust, and loses its right to recover in respect of a breach of duty causing damage to the trust, and that the cause of action is for loss to the trust fund, and that simply doesn't survive following redemption, and that the terms of redemption on which redemption is achieved is a matter for the internal regulation of the trust. So that's the first point. And then, my lords, my lady, if you could then read the next paragraph, please.
Yes.
So, again, we rely on the fact that the court is here rejecting the submission that the former beneficiaries gain on redemption some right to sue which they didn't have previously. And the next point that's being made in that paragraph is, well, if what's being said is that before redemption they managed to organise things in such a way that they could, that some of the benefits would be passed on to them, that's one thing. And if that were true, that would be a complete answer to the windfall submission. And then, please, if you could then read the next paragraph over onto the following page. And so again, what's being said is that, on the other hand, even if there's no subsequent right to claim some of those proceeds, that would still not be a windfall. So even if the proceeds of the claim went to the current beneficiaries and couldn't be accessed because of the nature of the arrangements by the former beneficiaries, that wouldn't be a windfall. Because what's being said is that the so-called windfall, and again we emphasise these words, is no more than the proper restoration of the trust funds, inuring for the benefit of those who happen, for the time being, to be the unit holders in these trusts.
Right, so when I said overcompensation before, you'd say so-called overcompensation.
My lord, precisely right. So again, it comes back to the 2 points that I made in response to your lordship's question to me at the outset. That first of all, we say so-called compensation because that's not how one looks at a trust. The trust, and we rely on this latter point, because the windfall, as the court says here, is no more than the proper restoration of the trust funds and inuring to the benefits of the beneficiaries at any particular time. So that's the first point. And the second point is that we say that whether or not there is so-called overcompensation or a so-called windfall will depend on the internal arrangements. There may well not be. And really, the fundamental point being made here is that these arrangements, trust arrangements, are workable because the parties involved choose how to regulate their relationship. And so, as I said, a beneficiary might negotiate arrangements such that if it redeemed its investment at an undervalue, then the trust would have to make that good if it received compensation. Equally, in those circumstances, the trust might say, if the beneficiary redeemed its investment at what turned out to be an overvalue, there had to be some making good. But that's purely a matter for the internal regulation of the trust. And we said in our argument, in our skeleton argument, and I don't take you to it now, that materially the same conclusion was reached by Mr. Justice Newberger, as he then was, albeit obiter, in Chappell and Summers and Blake. In other words, that the fact that beneficiaries change doesn't affect the application of the general rule. So we accordingly contend that only the trustee funds can sue for damage to the trust property caused by the bank's FX manipulation. Beneficiaries don't have their own right of action, and they don't acquire one simply by redeeming their investment. And I want to take you to the judgment below briefly to show you how the judge addressed this. So this is in the first core bundle behind tab 10. And if you could go to page 129, please. And paragraph 78, if the court has that. So the beginning of paragraph 78 records our submission, and then...
He wasn't taken to Young and Murphy, was he?
He wasn't, no. We hadn't discovered Young and Murphy at that stage.
I understand.
Now, so halfway, so that records our submission, and then halfway down the paragraph, the judge says in the law of trust, the general rule, so he recognises the general rule, but he says it's only a general rule and it doesn't preclude actions by the beneficiary where a duty is owed to him, which is breach and which caused him loss. Now, of course, our point is, well, a duty is not owed to the beneficiary because it's damage to the trust property. And that's the general position in English law. And then he says it was then submitted that if the beneficiary is unable to sue, it makes no sense to allow, while he is a beneficiary, it makes no sense to allow him to sue once he redeems for no new loss has been suffered by him. So that was our submission, that you can't draw a distinction between current and former beneficiaries. And the judge says it's perhaps true that no new loss has been suffered by him, but once he redeems his investment, his loss has crystallised. His investment has fallen in value, but his loss had fallen in value, but his loss hadn't crystallised because the value of his investment might rise in the future. But once he's redeemed it, it's crystallised because it can no longer rise in the future. The reasonable man would regard him as having suffered a loss, and I see no reason why the court should not also regard him as having suffered a loss. And we say that with respect and in fairness, as Lady Justice Carr points out, we haven't taken the judge to Young and Murphy. So in fairness to the judge, he hadn't seen that authority. But we say that the judge is wrong on this point. There is no concept in English law of loss crystallising or not crystallising. The loss at all times is loss and damage that's been caused to the trust property. And we say that the only case we can find in which a court has grappled very specifically with this supposed distinction between current and former beneficiaries is the Young and Murphy case, and we respectfully say that the court in that case got it right. And again, we say that it's all a piece with Elliott and Hatton's, that the loss is suffered at the time the value of the beneficiary's interest in the fund is reduced, and there is no separate loss which occurs on redemption when the beneficiary chooses to dispose of his interest.
So really the argument runs along exactly the same lines
really
as it
does.
does in company.
It really does, my lord, yes. So it does. In company law, there's the specific rule in prudential that applies only to company law, but we say that the rule in trust law that's specific to trust law, which I took you to in Webster, and which is reflected in the rule of practice, and which was addressed by the Victoria Court of Appeal in Young and Murphy. The rule in English law is to the same effect, that where you have damage caused by a tortfeasor to trust property, then that is damage which can only be recovered by the trustee, and there's no separate cause of action.
Did the judge refer to, forgive me, my fault.
Well, the point I was asking about was the timing point, which was the crystallisation point. It's that which I was asking you whether really the analysis ran the same way in trust law, albeit with reference to different decisions.
It runs exactly the same way, and it runs exactly the same way in relation to partners, and so I can take you very quickly through the partnership issue because it all runs exactly the same way.
So my intervention was simply that did the judge deal with Webster? In terms, is it part of his paragraph? Is it part of his paragraph 57?
Does he deal with Webster? He certainly dealt with Chappells and Summers. So, my lady, I'll come back to you on that. The key point, really, in response to my lady's question, is that he did accept the general rule. So he accepted the general rule that where damage is caused to trust property, which is the purpose, is why I took you to Webster, where damage is caused to trust property, that is damage which can only be sued for by the trustee, and there's not some separate cause of action conferred on the beneficiary. And the reason that he rejected our case on trusts is because of this supposed distinction between current and former beneficiaries. So he wasn't taking issue with the point in Webster, even if...
as far as I can see from a search, Webster only appears in this core bundle as a bottom of a long footnote at page 49.
I'm so sorry, page 49 of...
the core bundle. That's the only point at which Webster crops up.
Well, can I just take you then to paragraph 57 of the judgment?
Yeah.
So page
The first
page
sentence
1, 2,
there.
3.
57.
Paragraph 57, page 1, 2, 3. So again, he says there's no doubt that the general rule in English law is that where trust property is damaged, the trustee as legal owner of the trust has title to sue in respect of the damage. So he's accepting the general rule, but he then says where a duty is owed not only to the trustee but also to the beneficiary suffers a loss, and the beneficiary suffers a loss, the beneficiary can have title to sue. And
It is all about duty being owed, but where does he grapple with or where does he get the idea that on the facts here a duty would be owed?
so he gets the idea from Article 101, which
I see,
I'm going to come
right,
to.
of course, yes.
So he says, well, there's a separate duty under Article 101.
Yeah.
And in a sense, but in fairness to the judge, he deals with the Article 101 point first,
before.
because to him it comes logically, you're right, my lady.
So it's all about the duty being, a separate duty being owed to the beneficiary.
Yes,
As being the gateway.
that's right. And so
Right.
he says, you identify this separate duty to the beneficiary, and that's the gateway. And he says that if there is a separate duty owed to the beneficiary, then English law doesn't prevent that duty being exercised. And of course, we say that there's not a separate duty owed to the beneficiary. So as a matter of English law, if one's looking at a breach of statutory duty case, so forget EU law, take a straight breach of statutory duty claim in tort under English law, we say that, that where a breach of statutory duty causes damage to the trust property, then the trustee can sue in respect of all of the damage. And so, so that's the position in English law. And what I'm going to come on to say, I'm going to deal separately with Article 101, is that position isn't disturbed, or rather isn't reversed by Article 101, because Article 101 doesn't require there to be a separate cause of action on the part of the beneficiary.
Is that a good moment?
It's a very good moment. Thank you.
How are you doing?
I'm actually doing. I'm not going to overrun, so I will finish by the end of the afternoon, and I may finish a little sooner.
Thank you very much.